Welcome to Global Information Security Society for Professionals of Pakistan.
All right, Jay. So today is our last domain for CCSP. So after that, we had good review sessions, and I hope everybody gained something out of it and help them in, for preparing for the exam. So, and I, thank everybody who participated along the way and, asked questions and keep it lively. And, it was a good discussion. I actually learned a lot as we progressed through this overview sessions. So today is the last session, which is domain 6, which we're going to talk about legal risk and compliance aspect of cloud security. So this session, I'm just going to be talking about, some major aspects from this chapter. The rest, I expect that you study on your own in the book, understand what are, various legal and risk requirements and what are various frameworks that are out there that can apply to, cloud environment based on your own organization. So whether it would be a contractual requirement or it would be a regulatory requirement. So whatever the case may be, this domain will help you, ask the right questions and understand what your requirements are, whether it be legal, risk, or compliance requirements, and then, take appropriate actions based on that. So let's start off with this domain. So in this chapter, in this last domain, you're going to be mainly talking about 5 or 6 areas. So those will be around handling unique legal and regulatory requirements, what is data privacy and what are the issues around data privacy, what is audit and how audit can help a cloud service provider and their customers to have business and have contracts written based on that. What is importance of negotiating and creating cloud contracts. So, cloud contracts basically boils down to you need to understand your legal requirements, regulatory requirements, and if there have any data privacy requirements that you have to comply with. So let's first talk about what is evaluating legal risks specific to cloud computing. So what are various things that we talked about, and we have talked about these things quite in depth in our previous sessions. So first one is we all know that cloud is not a localized entity, as we are all familiar that when we have our own data center, it is localized, it is within a geographical boundary of a country or a state or a city. So local laws apply when we do business on-prem. But when we talk about cloud, cloud spans on multiple geographical locations across the globe. So the question is that every geographical location, every country has their own governing laws that they have to abide by. They have their own jurisdictions, and countries cannot, cross jurisdictions when it comes to implementing those laws. So from legal perspective, it gets difficult on how do you, protect the data that is spanned across a geographical location, and question comes in as to how you're gonna implement laws in case a data breach happens or a misuse of data that might happen. So the simple answer to that is that, the cloud service provider is bound by the laws of the country in which they are incorporated as a business. So that is the answer. So Amazon, Microsoft, Google, all of these large cloud companies, they are incorporated in US. So now even if the data that has been distributed across the globe, since these cloud service providers are incorporated in US, so they are governed by US laws. So from a legal perspective, this provision usually means that the laws and regulations of cloud service provider home country gets the final say whenever a dispute or conflict arises. So the main point is that where those cloud service providers are incorporated. Second thing we're going to talk about what are the risks is data location. So cloud providers permit customer data to be stored and processed at any of their data center locations. So if your SLA or other contractual agreements do not explicitly prohibit the CSP from maintaining your data across multiple geographical locations, then it is a fair game. So as I mentioned previously that certain entities, because of various security reasons, they do not want their data to be crossed over to geographical locations. And one of those entity type is federal or government of any country. So since that data is very specific to government, and obviously governments do not want their sensitive data to be stored in servers of another country where there is a higher chance of their sensitive information to be compromised. So in the contract, it is explicitly written that data of government should be and must be stored in a location of that, within the geographical boundary of that country. Case in point, US federal government don't even store their data across Canada, and I'm sure Canada is doing the same thing. They do not allow their federal data or government data to be stored on the locations of AWS, Azure, or Google Cloud Platform in US. So these are, you have to be very clearly defined in your contract on how your data is handled and where your data is stored. Otherwise, customers like yourself and myself, or maybe any other organization, our data is a fair game. It can be stored anywhere across, the country or across the globe, whatever the case may be. It's up to a cloud service provider to make that decision. Other legal risks that are associated with cloud computing is security and privacy. So cloud service provider, they promise you, or they agree to provide a reasonable security based on standard security measures. So while these standards are a good start, it's better to ensure that your CSP agrees to meet independent third-party security standards, maybe ISO 27001. So most of the cloud service providers, they do provide, a reasonable assurance that, security controls are in place, whether it be technical, managerial, or operational controls. They give you a warm and fuzzy feeling that, their data is secure, and their environment is secure, and whatever the data we are entrusted with them is also going to be secure. But it is always a good idea to have an independent third-party security assessment done. And we're going to be talking about audits later in the slide, that when you are going to have a contract with the cloud service provider, it is a good idea to actually ask for a third-party independent report talking about how that cloud service provider is doing when it comes to implementation of security controls and frameworks. So that is basically, it's a kind of an attestation that and a trust that you get established on a cloud service provider. Just because cloud service provider is saying they're good should not be good enough for you. You have to have a verification and attestation from a third party. Data breaches, so many countries and most US states have data breach disclosure laws. that require a cloud platform to inform customers when the data has been compromised. So customers should seek to have timing and method of communicating such breaches specifically outlined in their SLA and cloud contracts. So here is what happens. It used to be the case when if a data is breached or somebody's data is stolen, they were not obliged to basically tell their customers that, hey, you know, our servers are breached, data is stolen, and you are your own and do whatever you need to do to protect yourself. So, but with the laws and, you know, with the laws coming into being around that about data breach now in the US, especially if your data is breached, then companies are you know, asked to disclose that information to its customer whose data has been breached. And also, you know, they are obligated to provide services such as, you know, your credit score review so that they can monitor their credit score, because if their credit card information, say for example, is breached and if it's been misused, then they are aware of it. So there are many services. My data has been breached because I used to work for federal government, and you know, there was a big breach in federal government where my social security, my email, my home address, my name, my family name was also breached, right? And it was like 10 years ago. So the federal government then sent us, all of us, letters informing us that, you know, our data is breached and our data is my and my family data has been compromised. So they gave us free services to look at our credit scores. They provide us free services to monitor our social presence. So they gave us, you know, tools free of cost to make sure that if anything happens, we are aware that something has happened. So these are the laws. I'm not sure how it is in Canada or other countries, but at least in US, if data breaches happen, then organizations are required to disclose that and provide ramifications. Recently, I just tweeted about it actually. There's a big store over here, very high-end store called Neiman Marcus. They had data breach. They happened and they did not know for 17 months that they have been breached. It took them 17 months to detect the breach. So now in that 17 months, anything could have happened to the data of people, up to the people whose data have been breached. So which is a very, very bad thing to be now Neiman Marcus have to deal with. And that is why you need to have your SLAs and cloud contracts in place. So if data is breached, how soon cloud service provider is to tell you as a customer that data has been breached and now we have to take precautions. So you have to have those you know, clause in the contract. Intellectual property and data ownership. So IP is also intellectual property, is your copyright, your trademarks, and other intellectual property laws differ from country to another. So IP and data ownership risks can be limited through proactive contractual agreement of important requirements. So you need to make sure that if you are putting your IP, intellectual property, or anything on cloud, you need to make sure that cloud service provider does not claim it to be theirs. So it has to be you know, clearly defined in the contract. And we define that in US. I'm not sure how it is in Saudi Arabia or Qatar or any other country, but you know, these are the things, being a cloud service customer, you need to be cognizant of. The next concept that we're going to talk about under this is e-discovery. So I'm not sure how many of you are familiar with e-discovery, but it is a process of discovering you know, data, electronic data in an organization. And why it is important? It is important, especially in US government. There is a thing we call FOIA request, which is Freedom of Information Act request. And under that request, any US citizen can go to US government and ask for data. And by law, government is required to disclose that information to that citizen because of FOIA Act. So because of those type of procedures, so that is one scenario. Other scenario is there is a legal proceeding that is happening, some HR issue that might have happened, some contractual issue that might have happened. So e-discovery is basically is a method of discovering specific data through in your organization, and that would be in the form of discovering emails on a particular issue, discovering files on a particular issue, and whatnot. So e-discovery is an electronic discovery process that to collect, secure, and analyze that data as part of civil or criminal case. So whether it be a FOIA request in US or a criminal or legal case, e-discovery basically helps organization to discover that data and compile that data, analyze that data, and then produce that data so that it can be used under civil or criminal proceedings. You can actually go to this edrm.net website where you can read about the electronic discovery model and how it happens. And when we talk about various compliance requirements, various frameworks, whether it be Cloud Security Alliance, ISO, or NIST, all of them address e-discovery in them and how it needs to be done. So I've referenced a couple of them like ISO IEC 27050 and Cloud Security Alliance. All of these different frameworks, they talk about e-discovery and how it needs to happen. And there are various tools that organizations install on their systems, whether it be servers or workstations. And what they do is that those tools are constantly scanning these endpoints and indexing all that information. And as these information is get indexed, it makes much more easier for organizations to discover that information if a request comes in for a specific set of data. So e-discovery is a little bit different from forensics investigation, although it is kind of the same thing. But e-discovery is more of a live collection or live indexing of data. It is not after the fact. It is happening in a normal day-to-day course of the business. Forensics investigation usually happens after the fact once an incident happens. So that is kind of the thing. But the purpose of both of these things, e-discovery or forensics activity, is pretty much the same. Is basically collection of data, preserve that data, analyze that data, and then present that data. So from electronic discovery reference model, you can see that there are 5 steps that are involved in e-discovery. So number 1 is identification, basically locating and tagging potentially relevant digital evidence based on the details of the e-discovery request or order. I have been working in, as I mentioned, in organizations where these requests came in, and we had to run e-discovery tools to find information from specific emails about specific case. So you have to identify, you have to tag that information. And the tools that you use for e-discovery, they provide all of these capabilities in them for identification and preservation. And then place potentially relevant digital evidence in legal hold and ensure that it cannot be modified or destroyed. Again, just like in forensics investigation, once you collect the data, you have to preserve it so that it can be admissible in court. If you're not properly preserving the data, and you can preserve the data by taking fingerprint of the data, using various algorithms to make sure that the integrity of that data is not compromised. So preservation is very important. Collection is gather all potentially relevant digital evidence and prepare for review. processing and analysis. So collection may be from email servers, from email clients, from shared drives like SharePoint, maybe from a chat software, just like Microsoft Teams or Slack. So all of these digital communication tools, they are part of e-discovery. They can be part of e-discovery process if determined. Then you do a review analysis. This step is where your legal counsel typically gets involved with the digital evidence as they evaluate what you have collected for relevance, completion, and context. And then the production. So the last phase is digital evidence is delivered to external parties such as opposing counsel or a requesting authority. It may be, a court in agreed upon format via agreed upon means. So these are 5 basic steps in e-discovery. Any questions? Any comments? Okay. So next we're going to talk about privacy issues in the cloud. So privacy entails limiting access to personal information to authorized use. So you need to understand when we talk about privacy, privacy is actually very focused on in maintaining the confidentiality of personal information. So remember that P for privacy, P for personal information, specifically rather than just any kind of sensitive data. So anything that is personal, which we call PII, personally identifiable information, and anything that falls under PII category, that is fall under the umbrella of privacy issues, right? So that would be your phone number, that would be your name, first name and last name, your home address, your any other information, your email address that can be used and tracked back to your identity. So all of that health information also. So any of that information falls under privacy issues because they are tied to a person. So privacy is a bit like of a missing fourth leg in CIA. We all know that CIA is not Central Intelligence Agency, but confidentiality, integrity, and availability. So privacy complies with confidentiality. It complements all 3 tenets, which is confidentiality, integrity, and availability, but is its own beast that deserves individual attention. So that is why organizations usually have a separate privacy organization within the organization whose function is to basically look at these systems to do privacy impact analysis, which we call PIA, privacy impact assessment. So, I mean, we have heard about business impact assessment. That is a whole big thing, but a lot of federal organizations and large organizations like Google and other tech companies, they perform privacy impact assessments to make sure that the security controls that are implemented on their systems should not compromise the privacy of the individuals if the system is storing that data in them. So privacy impact assessment is a whole big field on its own. Now, when we talk about privacy, what is the difference between contractual and regulated private data? So privacy, we can divide into 2 aspects of it. One is contractual privacy. So cloud customers often gain this assurance by working with their prospective CSP to place specific requirements on the handling of and protection of PII. So in this case, cloud customers, they might not have to meet regulatory requirement for privacy, but for a number of other reasons, they want to keep that data private. So that way they can, work with cloud service providers and write a contract in a way that protects the privacy of individuals on the cloud in the cloud service provider data. So these requirements can range from broad policies such as who may access PII and what uses of PII are permitted or forbidden, to specific controls that might be in place. So let me give you an example. I'm sure every one of you heard about Swiss banks and why people open accounts in Swiss banks, right? And the reason in those Swiss banks is that there are no regulations, but there are privacy, contractual privacy in place, because those banks are contractually bound to protect the privacy of their clients. Now, if one of those banks, has hire a cloud service provider, maybe in Switzerland or Swiss areas, then that contract will not be bound by any regulation, but a contractual privacy agreement. So that's the example of contractual privacy. Second one is regulated private data. So certain type of private data must be protected by numerous laws and regulations around the world. So regulated private data must be protected even if a customer does not specifically requested it to be. So example is PHI, protected health information. So let me ask you, what is one regulation in US that protects PHI? Anybody? Or if you have something.
Is that HIPAA?
Yes, that is HIPAA, that is correct. So now, if federal government or any healthcare provider, right, collecting that information of their patients, although patients do not specifically ask to protect their information, but those healthcare providers are bound by the law, which is and regulations to protect that information. And in that case, that regulation is HIPAA, right? Another example we can take is in financial industry, right? We do not ask Visa or MasterCard or Discover to protect our private information, but they are bound by PCI regulations to protect that information. Same goes with banks. Banks in US have to protect their client information by FINRA. I think FINRA is the Federal Information something that requires banks to protect the information of their clients. So those are regulated industries. Okay. I'm not sure if Pakistan has something like that, some regulations like that that may protect, ask financial institutions or healthcare institutions or banks to, protect information of their customers. So, expanding on that, so what are various country-specific legislations related to private data? So in United States, we already talked about HIPAA is one of the regulations that protect PHI information, personal health information. Then you have GLBA, which is Graham-Leach-Bilili Act. So Graham-Leach-Bilili, I think these were 3 senators who actually, came up with this act to protect financial data. So Graham-Leach-Bilili Act falls for financial institutions. Then in Canada, we have PIPEDA, which is Personal Information Protection and Electronic Documentation Act. So this act basically, regulates personal information on institutions who are basically storing personal information of their clients. So everything falls under PIPEDA. And in European Union, we all know GDPR, General Data Protection Regulation, and that is the regulation that protects all of the information of citizens of European Union. And it is sometimes somebody, I think in our group, asked this question: what if a European Union citizen comes to US and falls sick? Now that person goes to a US hospital. So under which law that citizen information is protected? Would that be GDPR or would that be HIPAA, right? So to solve that problem, they came up with a combined, both US and European Union, they come up with a solution where both of their citizens' information is protected in both of the countries. Okay. So ISO IEC 27018, it's another standard which was originally published in 2014 and was most recently updated in 2019. So this document expands on ISO 27002 to establish a standard code of protecting PII in public cloud environments. So just remember that that 27002, it is important to remember these numbers from the examination point of view, because you will get some of the questions around these specific standards. So IEC 27002 is for protecting PII in public cloud environments. And what it does is this particular section, it assists CSPs in compliance with contractual and regulatory privacy requirements. It also enables CSP to be transparent with its customers about how it handles PII, in turn enable cloud customers to select CSP that handles PII in a manner that fits their need. Assist the CSP and cloud customer in entering contractual agreements by providing a clear framework for discussing and handling privacy concerns, and also provide cloud customers with mechanism for measuring CSP compliance with privacy obligation by requiring they undergo periodic and independent audits. So one thing that for the people who are not in a country where regulations are a big deal, right? Their regulations are not them. Let's take an example of Pakistan maybe, or any other country for that matter, where regulations like HIPAA and PCI or other are not. Then the customers of cloud service provider in those countries should opt for contractual privacy, right? So you have to have some privacy requirements in the contract that you can bind your cloud service provider with. So if regulatory contractual requirements cannot be applied, they are not applicable because of the geographical region, then use contractual privacy and use these documents like ISO IEC 27008 or 27002 as a guiding principle to write those contracts. So that is something that your organization can do when they intend to do business with cloud service providers. So that's something that can be handled that way. Then we have generally accepted privacy principles called GAPP. So these it is a privacy framework that was published in 2009 by a privacy task force. It is created by American Institute of Certified Public Accountants and Canadian Institute of Chartered Accountants. So GAPP is focused on privacy, and the main areas that GAPP covers is management of privacy information. So define, document, communicate privacy policies and procedures to impacted parties and relevant stakeholders. Then notice, as I talked to you mentioned before, that if your data is breached at a cloud service provider, they have to notify all the parties who are impacted by that breach. Choice and consent, obtain consent from impacted parties to collect, use, retain, and disclose their PII. I mean, right now, look at Facebook and look at social media platforms. It's kind of free for all. I mean, they are just collecting your information and distributing your information pretty much without your consent. I mean, they have this whole huge, privacy notice, which nobody reads, right? And then just click yes, and then start using those platforms. And those platforms are basically collecting that information and using that information however they see fit, whether it be political reasons, religious reasons, or other reasons, right? And you have no control over that. Now, GDPR in European Union has much better privacy policies under GDPR than in US and Canada, I believe. Facebook and other social media platforms have to be very careful in those countries on how they use and distribute information that they collect about their users. So it is very important to have these privacy laws implemented so that your information does not get used. Just on a side note, I've been working on a small project, being a security conscious person, and I do all of these various things on the side because I just like to do that. So there is, if anybody of you are an Android user, you can basically build your own custom ROM install on your Android cell phone, which we call a de-Googled phone, because Google collects a lot of information, right? So you can make a de-Googled phone where you are not connecting to any of the Google services, but rather using alternate apps, and that phone is very, very, very secure, and it's very good to protect the privacy of your individual if privacy is of your big concern. And one of that OS that has been developed with privacy in mind is called Graphene OS, GRAPHENE OS. You can actually download that Graphene OS. It only supports Google devices, Pixel 3 to Pixel 5 and some other devices, and you can install that. It's very clean. It does not have any trackers in it, nothing on it, and you can just use that phone and stay invisible. Yeah, I can give you the link. I mean, this is something on the side that I was just want to mention. Let me open it. It's called Graphene OS. So you can go to this website and you can download it, you can install it, and there's all of the information in it. And so this is one, and there's another one which we call Lineage OS. Lineage OS. So this one has a much broader implication. You can have multiple phones. It supports a lot of hardware that you can install it on. You can actually go to Wiki and see what are the supported devices, and if you have that device, you can basically install it. And if you want to install apps, the best store it's called F-Droid. So you can install F-Droid on these machines. It's just like Apple Store, and you can install very good applications which are very privacy conscious open source application. So I have one phone that is running Lineage OS and F-Droid, so it's quite secure. So yeah, I mean, if you are security conscious, so these are the type of things that you can do to protect your privacy and security. All right, so we talked about consent collection, limited PII collection to what has been committed to consented and impacted, use, retention, and disposal, how your PII information will be used, how it will be retained, and how it will be disposed, access, disclosure to third parties, security for privacy. All of these various, I think, aspects are covered under GAPP, which is generally accepted privacy principles. Thank you, Batisa, for posting the links. Okay, so understanding audit process. So now, as I mentioned, that whenever you, especially under contractual privacy requirements, whenever you are hiring or whenever you're acquiring a cloud service provider service, you can ask them to provide you third-party independent reports or to see how their security is. So one of the process of verifying is performing external audits, right? So external audits are the ones typically performed by an independent third party that comes in and assess your system security. So it could be Deloitte or Accenture or any other big four companies that does these audits. So they come in, they assess a cloud service provider security, and then they issue a report based on what they have discovered. And that report can then be used by a cloud service provider to share with their customers to show them that they have done their due diligence, they have conducted audits, and they have and they are in compliance with a lot of various security requirements. So independent external audits are necessary to provide customers and regulatory assurance that CSP is meeting all of its regulatory and contractual security and privacy obligations, right? So most organizations and just about every cloud provider should have an internal audit department. So we talked about external audit, but now we're going to talk about internal audit departments. So there's external audit, there's internal audit, right? So internal audits act as an organization's third and final line of defense against security threat and can be used to catch potential security or compliance gaps before external auditor does. So usually external auditors audit happens every 6 months or a year or a 3-year, whatever the regulatory requirements may be. But what happens after one audit happens and between the next audit, there is a time, right? So, you know, it so happens that over that time, maybe security of that cloud service provider or that organization deviates for whatever the reason may be. Maybe the controls are no longer effective. Maybe their change management is not very effective. So whatever the state of audit that they have report that received, it might not be as secure after 6 years or a year. So how do you make sure that, you know, during that gap, you know, you're still in compliance until the next external audit comes? And that's where internal audit comes in. So internal audit is basically, I would see it as a continuous monitoring type of process where you're continuously monitoring that, you know, our organization is still in compliance with regulatory requirements. We still have all the security controls that are in place, and we are still meeting with our privacy obligations before, so that when external audit comes in a year after, we do not fail that audit, right? So that's the main function. And there are other various functions of internal audit that happens, but that's one of the key functions. So line of defense, if you remember in the third bullet, I talked about line of defense. So this line of defense terminology is very common in banking industry here in US, maybe in Canada as well. So in financial and banking industry, they look at security in 3 layers or line of defense, right? First line of defense, second line of defense, and third line of defense. Internal audits, they provide as a third line of defense. And what are the 2 line of defense before internal audits? We're gonna look at in the next slide. And again, this is very much common in banking industry, and that's where I have seen it when I was talking to my banking clients, they talked about this line of defense very often in their discussions with us. So the first line of defense includes the information security department and the actual business units that own the cyber risk and controls. I mean, you know, that would be your internal cybersecurity department implementing firewalls, intrusion detection systems, antivirus softwares, making sure your operating systems are secure, you know, network is secure. So that is your first line of defense. So your information security department that does all those functions, they fall in the first line of defense. The second line of defense is your organization risk management function that looks at aggregate risk at an enterprise level. And that would be the function that usually we call a compliance and regulatory function in an organization. So most of the large organizations have a specific legal department and compliance department that basically works with first line of defense, and they also works with the third line of defense. And they are kind of in the middle of these two lines of defenses. And their job is to make sure, the overall risk is managed, the overall, any regulatory issues, any regulatory irregulatory regulations are managed, and the overall enterprise risk is managed. Anybody of you I'm sure you have worked with organizations as an internal auditor, right? Or you maybe work in a risk and compliance department, right? So those type of jobs fall in the second line of defense in an organization. Anybody work with a tool called Archer? So Archer is a tool that is very popular among various industries in US, again, especially banks. And Archer is a tool which is an enterprise risk management tool, which basically collects a lot of information from various sources, right? Whether you are conducting penetration testing of your network, penetration and vulnerability testing of your application, you are doing framework type of assessments, maybe NIST framework assessments or ISO assessments, right? So all of those activities generate various risks, right? And various aspects of risk. All that information then gets aggregated in this Archer tool, which has algorithms which basically looks at all those risks, combine that risk, and then give you a overall risk level. And that's what we call the enterprise aggregated risk level of that organization. And all these activities happens at the second line of defense. And then the last one is the third line of defense is your internal audit function. So when people do CCSP certification, right? Either they work for a consulting company, right, Accenture, or whatever other big four companies out there, Booz Allen, as an auditor, or these folks work at an organization, maybe at a bank as an internal auditor. So being a CISA, their responsibility is to conduct these internal audits, work with the second line of defense, work with first line of defense, and making sure they are in compliance with regulatory and privacy requirements on an ongoing basis. Okay. So there's a question about by Rashid Hussain about these things. So these will be recorded and will be available on YouTube for you to look at on GISPP channel. All of my previous lectures, all 5 domains are there, and you can watch them free of charge. Okay. Types of audit reports. So this topic is of particular importance in from examination point of view. You will get questions about SOC reports, which is Service Organizational Control. I got, I think, about 2 questions. I do not know exactly what those questions were, but this is a very popular topic from audit report, from audit topic point of view. So audit report is a set of documents and artifacts that describes the finding from an audit and explain audit's opinion of system that was examined, right? So these reports have been standardized by various entities over the years, each tailored to a specific industry or audience. So as I mentioned, that audit happens internal versus external, and each and every audit owns specific reporting requirements. It has its own specific, process requirements, right? So one of those is SSAE, which is stands for Statement on Standards for Attestation Engagement. So SSAE 18 is a standard published by AICPA, which we talked about just previously, that is focused on audit methods. So SSAE imposes requirements on organizations to evaluate and report on their third-party vendors, security, and risk profile. So SSAE 18, audit can be of various types, right? It could be financial audit, it could be IT audit, it could be cybersecurity audit, right? So audits are different, and maybe one audit document covers various areas of audits, right? So for SOC, one of that type of audit is we call SOC, which is Service Organization Control. So SOC report comes in 3 types. So now this is a little bit confusing, but it's not that difficult. So you need to understand, and I have to emphasize on that, that you need to understand all types of SOC for exam purpose as well. So SOC 1 is a control report that focuses strictly on organization's financial statement and service organization controls that can impact customers' financial statement. So as I mentioned, there are specific purposes and there are specific types of an audit. So SOC has 3 types, right? SOC 1. So remember, SOC 1 is all financial focused. It has nothing to do with IT. It has nothing to do with security. It is all financial. SOC 1 reports are considered restricted use reports. Now, who is the audience? So first of all, first one is type. Second thing is, who is the audience of that report? Means who can see that report, right? So SOC 1 reports are considered a restricted use report, meaning that they are restricted to limited scope of controls and restricted to limited audience, including service organization management, controller, and auditors. And that's about it. Nobody else can see SOC 1 report until or unless maybe there is a court order about that, right? You know, shareholders don't see that report. Customer or users of the service of an organization do not see SOC 1 reports. It is strictly for that organization own management, that controller, and the auditors. So let's expand on SOC reports. So what are the type of SOC reports? I mentioned SOC 1, SOC 2, and SOC 3. So let's talk about SOC 1. So SOC 1 is a detailed report over financial and auditable controls for an organization, right? It is detailed and thus sensitive. It is very detailed. Remember that. So you have to remember these specifics of each and every type. It is very important, right? And thus sensitive. It might be requested of an organization that processes financial data, such as a payroll company. In America, one of the large payroll company is ADP, right? Automatic data processing. And that is the company that is regulated and they are required to produce this SOC 1 report, right? So then SOC 1 has, there are 2 types of reports under SOC 1. SOC 1 type 1, SOC 1 type 2. We are still at SOC 1, right? So the SOC 1 type 1 report, but scope for a particular date, because it is a date instance. It is not telling as type 2. So maybe we want a point in time audit, financial audit. So SOC 1 type 1 is tied to a particular date. Maybe, you know, auditor is requesting that I need, or organization is requesting an audit for a particular date, right? And that audit will be produced a SOC 1 type 1 report. Again, the audience will be very limited. Then we have SOC 1 type 2 report. It is scoped to a particular date range, maybe from within a fiscal year of an organization, from January to July. So that audit covers that specific range. Because it covers a date range instead of an individual date, it is more thorough and telling report. So this report has more information because obviously it is spanned over multiple maybe months, right? It has a range associated to it. So SOC 1 type 1 is for a specific date. SOC 2 type 2 is for a range. SOC 1 type 1 is not as telling because it is a very point in time capture. SOC 1 type 2 is more telling because it has more data spanning over multiple on a date range. So again, so that's SOC 1. Then it comes SOC 2. So this is a detailed report on organization controls over the areas of security, availability, processing integrity, and confidentiality or privacy. So you might provide this to a prospective client to prove your security posture before selling your cloud service. So you can, as a cloud service provider, cloud service customer, ask your cloud service provider to produce a SOC 2 report for your review before you make a decision whether if you want to go with that specific cloud service provider or not, right? So then SOC 2 also has two types. SOC type 1, this is a SOC report for a given date instance. It proves compliance at a given type. And again, just like SOC 1 type 1, it is SOC 2 type 1 is tied to a specific date instance. And it is less thorough because it is tied to a specific date. And SOC 2 type 2 report is for a given date range, minimum of 6 months, and thus proves that organizational controls listed are operational and enforced. So this is a better report than type 1 and more expensive, right? So if you are an auditor, you are working for an auditing company like Coopers and Lybrand or other company, then you have clients that ask you to do these type of audits, right? And then you go in and you do these type of audits and you produce the report and give your client, and then your client choose then to distribute this close to their customers to get business. Then we have SOC 3, which is the same as SOC 2, except that it is much more generalized, short, less sensitive document. This is intended to be more of a public-facing document. So there is no separate types of SOC 3. It's just a report. It's a concise version, and it is more public-facing. And I think you can find this report by just asking the organization to provide it to you, because it's a very public-facing documentation. Another just for the general knowledge, any company that is listed on stock, especially in US, there's an organization called SEC, Security and Exchange Commission. That organization asks all the listed companies to provide yearly report, and that report is publicly available, and it is available for everyone to look at. And that report is called 10K report. You can actually search for 10K report. Go to Google and search for any publicly listed company in US and search for their 10K report. And we use that 10K report to see how that company is looking to invest in their cybersecurity. It covers various areas, and cybersecurity and risk management is one of the areas listed in 10K reports. That basically describes how that company has done last year. What are the areas they are, thinking of focusing on next year. So being a consultant, being a business owner, if you're a consultant, you can read those reports and you can get a lot of information about your prospective clients who maybe are listed on stock exchange and, come up with business proposals. Okay, so moving on, this is a small chapter, so we should be ending pretty soon. Restriction of audit scope statement. Now, when we do the audit, we just cannot go in an organization and start auditing everything, right? We have to define a scope of the audit, and then so that both our client and we as an auditor stick to that scope and deliver and perform that auditing activity in a given amount of time and produce a very specific report. So having that scope statement is very important. So before a cloud provider or any organization for that matter undergoes an audit, they generate a set of audit scope restrictions that set restrictions on what an auditor may or may not audit, right? So what are those basic areas? First of all, identify assets that are out of scope. Now, I'm being an auditor, I cannot go into an organization and, just audit each and every asset in that company. I have to be very limited. So that company, if I'm going in for, say, a PCI audit. So let me give you an example. I did a PCI audit for a transport company here in US. So I cannot audit anything outside the systems that are specifically designated for PCI data processing, right? Obviously, they have their own user PCs, they have their own servers with their own data, but then they have a network that is designated for processing PCI information. And information in that PCI network was coming from all of the kiosks across the state where that transportation was being used. You know, people going into that kiosk, buying tickets, using their credit cards to buying tickets to get on the train or transportation. So all of that data was being processed at this PCI specific network. So when we went in to do the audit, our focus was only on that PCI network, and that includes the routers, the switches, the servers, or any other computer that was involved in getting, storing, and processing PCI specific information. Any other thing in that organization was out of scope, right? So you need to identify the scope. Second thing is identify blackout periods. So what are blackout periods? So blackout periods are any time of the week where auditing is off limits. Maybe you go in, and sometimes auditors have to do technical assessments. They might be running an SS scan. They might be running a port scan as part of the audit, right? So you have to understand and of that organization might have blackout periods. And in those blackout periods, you cannot conduct those activities as an auditor because that organization during those blackout periods might be patching their systems. Other type of upgrades are going on. They have other deployments going on. So during that time, during those blackout periods, you do not conduct audit activities. And then you have identify unacceptable tasks. Auditors come in and they want to do all sorts of testing. They are hyperactive. They just want to do anything. They want to show their authority. And they're going to ask you, show me this, show me that. I need to see that artifact. I need to see that artifact. I need to run this test. Sometimes they do that, right? And especially I've seen usually in the large 4 companies, young kids that they hire right out of school, right out of college, and they come in as auditors and they are high on their horses. They think that they're something, and they start doing their audits. And then you have to manage them. You just don't give them whatever they're asking for. You have to give them within the limits. So identify unacceptable tests. Auditor free range to choose the testing, but many restriction types restrict certain type of tests. Particular disruptive tests that may cause outage or loss of data. And these things happen sometimes. Again, auditors comes in, they are not very experienced. They do not know how to conduct certain tests, but yet they feel overconfident and they run those tests. And what happens is they may end up, damaging your system or your data or whatever the case may be. So to avoid those occurrences, when you do the audit, you need to make sure that these restrictions are agreed upon. And auditors should not have free rein to do anything what they want, right? And if anybody of you over here is auditors, I'm not saying bad things about auditors. I'm just giving you, so don't feel bad about that. All right, so the next one is ISMS, which is Internal Information Security Management System. And again, going back to the previous slide, this department is your first line of defense in any organization. So ISMS is a set of policies, procedures, and system for systematically managing the security of information system. So like a cloud service offering, the main objectives of ISMS are to manage risk to organizational and customer data, ensure business continuity, and protect organization reputation. And we have talked in our previous slides in depth about business continuity and backups and recoveries and policies and procedures, training of employees, all of those things, firewall, routers, all of those things fall under the purview of ISMS. So ISMS is based on three things, and we talked about it. So people, process, and technology. So in any organization, your IT and cybersecurity is based on these three pillars: people, process, and technology. And we all know the weakest pillar in all three of them are people, right? So this is what happens. And I have to admit over here, I just recently fell for it. And our company actually ran a phishing campaign, and and I did not. And while I was doing my own work, the email came in. I was working with the client, and it was a timing, whatever the case may be. I clicked on that link, and I did provide my password, and I'm not very happy about it. It is a very shameful experience for me that I fall for it, and I provide my password as part of the phishing campaign. So, that's what happens. Things happen. And if I can fall for it, you can imagine anybody who is not in IT or not doing it can fall for it very easily. So, that was my one example from my Hall of Shame experiences. So one experience out of my Hall of Shame. So a large collection of security tools. Without meaningful policies. Yes, I do read all my emails because all of pretty much my emails are very important, and that's how it is. So a large collection of security tools is useless without meaningful policies and effectively trained personnel to implement and use them. All right, any questions so far? Okay. I think we are pretty much towards the end of our session today. So understanding the implication of cloud to enterprise risk management. So assessing provider risk management program. Anytime you use a third party or host or manage your data, you must understand vendors risk management. In this case, cloud service provider is your vendor. And if cloud service provider, buying stuff, they have vendors too, right? So which is kind of fall under into supply chain management. So it is essential that you evaluate your provider's risk policies and methodologies to determine how they align with your own risk management objectives. A good example is SolarWinds thing that happened recently. Everybody was using SolarWinds, but SolarWinds basically seems like did not manage their vendor who was writing code for them, right? And look what happened. Okay, so let's talk about data. So what is the difference between data owner versus data custodian or processors? So data owner or data controller. So a data owner or data controller is the individual who holds the responsibility for dictating how and why data is used, as well as determine how the data must be secured, right? So you being a cloud customer, when you are going to a cloud service provider and you are uploading your data, let's take an example of Office 365, right? We are using Office 365, which is an SaaS, software as a service. And you are using that service to create data in your organization, whether it would be Word documents, Excel files, emails, PowerPoint. So you are the owner and controller of that data. Now the data is being stored in Microsoft Cloud, whether it be OneDrive, SharePoint, or whatever the case may be, or maybe you are using Microsoft Teams. All of these interfaces, the data is being stored in OneDrive, right? So in that scenario, you are the responsible, being the data owner, you are responsible for all the data that you are creating using those services and storing in Microsoft Cloud, right? Same goes with your Gmail. You are responsible for your data, for your emails that you're storing on Gmail services. So in other cases like cloud, the data owner outsources that to a third party. Even when outsourcing happens, that data owner does not lose control of the data or associated responsibilities. No matter who processes the data owner is always responsible for specifying how the data is used, processed, and secured. So again, cloud is a shared security model. They provide maybe infrastructure level security or software level security, but you are responsible as a data owner for your data. If data is breached, you will be held responsible to your clients whose data you have stored on the cloud service provider network, right? So to do that, cloud service providers provide you various security tools, to protect that data. For example, when you buy Microsoft Office 365 service, they provide you Intune service. Why? Because that service helps you secure your data that you're storing on Microsoft. They also provide you Active Directory integration, access and authorization, multiple other tools that comes with Office 365 subscription that you can use to provide security to your data in the cloud. Any questions? Okay. Data custodian. So the next is a data custodian. A data custodian or data processor, simply put, is an individual that is responsible for adhering to data owners' established requirements for using and securing the data, and must process the data in accordance with the data owner's established purposes. So you as a data owner, entrusting you're storing your data, processing your data, transmitting your data on a cloud service provider network and systems, then they become data custodian because now they are holding your data for you, right? So the data custodian will only adhere to the data security requirements that you dictate, and how you dictate those requirements depends upon, again, it's a contractual privacy agreements, number one, that we studied previously, or it may be you are an organization that has to comply with some regulatory requirements. You are bound by some regulatory requirements, maybe HIPAA, maybe PCI or FINRA or GDPR or PIPEDA, whatever the case may be, wherever you are located. So based on those contractual or regulatory requirements, you tell your cloud service provider that this is how my data needs to be secure, and you have the responsibility as a custodian to save that data with the requirements that I am providing you as a customer to secure my data. Okay, so data custodian will act on instructions to provide security data provided by you. And that could be, do not store my data outside the geographical location. Like US government tells a cloud service provider, do not store my data outside the US geographical boundary. Yeah, so data owner is ultimately responsible. And tools are obviously provided by all three major cloud providers. If you're using some small cloud service provider, then you have to implement your own tools to provide that security. And one of the biggest tools for data protection is encryption. Encrypt your data.
Ransom, I have a question. Can I on this? Yeah. Sure. Just so you know, I've been actually out of the US for the last 4 years, but on the data custodian perspective, we used to get calls from our credit card processor like Capital One or Chase, and folks were sitting in actually India and they had the social security. Once they have, once you give them all your personal information to access your account, they were able to see everything, right? And now you have your routing number and in your branch code that is given to them for like auto pay for some sort of, auto payment arrangements. Now, there was a couple things I see, a couple red flags. One is obviously the data custodian sitting in India outside of US. And the second one is, you're sharing your routing number and then your bank codes, which has been a problem. I've heard that information has been sold onto the dark web, and though the scammers were able to access the bank accounts and grab all the money, right? So is it still the case for the US government has done some changes to it? Because there's no two-factor authentication either in these kind of transactions, right? Essentially, you're giving in your information. Like in the Middle East, the two-factor authentication is almost everywhere. And I was amazed to see that it's much more tighter in the Middle East than back in the US. So are you aware of any changes that are happening in this area? Because this is a sensitive issue.
Yeah. So US government doesn't allow any of its data to go outside US period, not even in Canada. So government organizations are abiding by that rule, right? Now, as far as private organizations are concerned, again, how the business is set up, how they are managing their resources. A lot of these data centers, call centers are out of India now. And this is a problem, right? The same laws does not apply in India, right? And they are taking that information away. So I think the customers of those organizations need to make sure they talk to those, or they need to pressurize. And there's a change that needs to happen. Maybe a law needs to be passed that US citizen information should not go outside the US and should not be stored outside the US and processed outside the US. So that has not happened as of yet.
All right, thank you so much.
All right. Okay, so understanding outsourcing and cloud contract design. I think that's where all those things comes in that you just alluded to in your question. So business requirements. So before you enter into a contractual agreement with your cloud provider, your organization must consider the needs and requirements of your business and determine how a cloud provider can help meet those requirements, right? So the way previously things are happening or still are happening is that those business requirements are lax because they are focused on bottom line rather than protecting the privacy of the individuals, right? So bottom line dictates how business operates, right? If their bottom line, if working with Indian call center helps their bottom line, obviously they don't care about the privacy of their customers, right? They're gonna send all the information outside US. They're gonna store information in India, and you being a customer of that business will be dealing with people outside the US. You will be providing that information to those people. So this is something that I certainly believe needs to be looked at, needs to be regulated and managed, and that is not happening right now. Vendor management is a process by which an organization manages risk related to vendor and ensures effective service delivered by the management. Again, another way is that whoever, that call center may become the vendor of a company in US, right? So they need to make sure that the vendor meets or exceeds the same requirements of data processing and privacy as we have in the US, right? So those are the things that a business needs to ensure that vendor comply with. Contract management is the process of managing contract negotiation, creation, and execution to reduce risk and maximize performance. Then the last one is supply chain management. So when using a cloud environment, you're using all of the cloud service provider technology as well as an external technology that they are leveraging, and so on. So creating a long chain of dependency known as supply chain management. Again, going back to the example of SolarWinds that happened, that was a supply chain attack that happened. Supplier who was a software writer, he did a hard-coded password in that code. That software get built and then get distributed to all of the SolarWinds clients. And what happens is when that software with that hard-coded password distributed to all the clients, it makes all the users of SolarWinds vulnerable to that particular attack. So whoever knows that hard-coded password now has access into all of the SolarWinds clients because he can access that software remotely using that hard-coded credentials. So supply chain management is very important. And a lot of US banks are now, looking into it. We have been working with our clients to develop, vendor assessment programs specifically focused on software development. So if they are, writing a piece of software for financial institution, the financial institution makes sure that their suppliers who are writing the software for them, they have certain security controls in place. Their employees are vetted. They are doing basic due diligence when they are writing the software. Their software security controls are in place. They have gates in their SDLC. Their SDLC is secure. So all of those things, are happening now. Obviously, a lot of financial organizations do not have that leverage, if they're using Microsoft or Google to tell Microsoft and Google to comply with, banking policies. Somebody is unmuted. Okay. So these things, these are very, tricky topics because if you have a bigger stake, only then you can, enforce your policies on your vendors. If you do not have a bigger stake, then, you are pretty much at the mercy of your vendor whom you are using the software of and, acquiring services of. So it's a very, tricky balance. Smaller vendors, they need to get the business so they can comply with. If one bank said to Microsoft, I don't want to do business with you because you're not in compliance with our policy, Microsoft gonna say, screw you, I don't care. I have many other clients I can go with, I don't care. You don't want to do business with me? Don't do business with me. I do not care, right? So it's all about money talks. All right, so this is the last of it. Any questions?
Yes, sir.
Sure, go ahead.
Okay, the first one is, let's say if we have a private cloud and we are providing the cloud services to our internal clients or internal departments, they are geographically located in different places, then how will we implement these controls? Like in Saudi Arabia, Dubai, Russia, China.
Depends upon where your organization is incorporated. Remember the first slide that talked about wherever the company is incorporated, wherever the business is registered, that's for there the regulations get applied to that organization.
Let's say like if I am in US, Russia, China, Saudi Arabia, and Dubai. What will happen in that case? And we are talking about a private cloud, not the public cloud.
Right. So if you are in US, then and if you are regulated organization, right? And so, for example, you are dealing with healthcare, then HIPAA law applies to you in your private cloud.
Oh, okay. So we'll go with the whatever country rules for the cloud. But even for our private cloud, we have to follow the same regulations.
Yes, because if you're dealing with healthcare industry, then you're regulated industry, right? Then you have to implement HIPAA laws. HIPAA rules apply to you.
I got you. And for the tools which I was talking about, where you were talking about the data ownership, some organizations do not provide all the tools to protect their data, like in case of Microsoft, not Intune's encryption or RMS or those type of stuff. So if in that case a data breach happened to the client data, then who will be the prime responsible? Like
Client,
is the
because
prime
you are the
responsibility?
data, ultimate responsibility lies with the data owner and not data custodian. So if you are the data owner, then responsibility lies with you.
Means the organization, not the user itself.
The organization, yes, yes.
Okay, okay,
Yeah,
you got it.
the organization that owns that data.
Okay.
Yep.
And in case of hybrid cloud with the same geographical organization, because I know I'm in oil field industry, so I know ABC of oil field industry. So they do have their offices in multiple countries, and they do provide their private cloud. Then they have hybrid clouds, and sometimes they go for public cloud also. So they have 3 type of cloud implementations everywhere almost. Mr. Tahir can confirm it if I'm wrong. What will happen in those cases? They will have different processes for each cloud service.
There might be, because I'm not sure what regulations apply to oil and gas industry. If there's any, I'm not aware of it. So that might be more of a, private contractual type of privacy requirements that might apply to them.
Let's say like if we are in US or in Canada.
Yeah, I
like,
do not believe that there is a data requirement. These are regulated industry when it comes to privacy, oil and gas. But yes, what they do is for their IT security and IT controls, they use ISO standard mainly.
Okay, and the countries like China and Russia, they do talk about like decentralized cloud, so they want to have their own cloud. They don't want to.
Yes. Yeah, I mean, China even does not allow Facebook. They use WeChat over there. Right? And WeChat is basically everything. Last night I was watching a documentary on AI in China, and it was amazing to watch. I mean, there is no concept of privacy in China. Government gets all the data, your facial data, any type of data they can have. In China, they don't use credit card anymore. If you want to pay, you just walk up to a screen, a camera looks at your face, and they just charge that money. That's about it.
Perfect.
So yeah, so China has no idea or concept of privacy.
Yeah, but like Russia, I heard they are going to control their whole internet. They will not allow anybody to open internet. They are also working on something.
Yeah. I mean, these are very political type of questions on how each and every country is and what is the political environment is, right? So, I mean, most of these countries, China and Russia, they do not have that type of regulation in place. I mean, they don't care about privacy. They don't care. They just care about control, right? And how do you get control? The more data you have, the more control you have. It's as simple as that. So there was a line from the documentary that if oil was gold for all these Eastern countries, then data is that oil for China.
Yeah,
I mean, they have so much data that it's amazing.
Yep, I got it.
Thank you, I recommend everybody to watch the documentary. It's on YouTube. It's a frontline documentary. It's called AI in China something. Just watch that. It's very interesting.
Sure, if you have it, you can share the links.
I'll share the link. Yeah, I'll share the link.
Thank you for a nice session, Andy.
No problem. Any other question by anybody else? Any confusions?
Yeah, one question from my side.
Sure.
This is about the SOC 2 report. SOC 2 report is a very detailed and restricted one. So as a consumer, we can ask from CSP for the SOC 2 report with any contractual agreement?
Yes. So you can ask your service provider to provide you with SOC 2 report. But with that, you have to generally sign a document called NDA, non-disclosure agreement, right? So once you have that document in place, which basically it's a promise that once you look at this report, you will not disclose that report content with anybody else, right? So if you are a client with with some power of, you have a large business that you can give to that cloud service provider. So with proper documentation like NDA, they can share that report with you.
Hazar Basha, one comment for you. If there is a rule of land, it will always supersede any standard. So if Saudi Arabia have a rule, it will always supersede the next ISO or any other standard. So you have to comply with that one prior to any other standard.
Yes, in US, if you request SOC Type 2, I know that you have to sign an NDA with the organization to whom you're asking to review the SOC 2 report.
Okay, sir. So should we finish the session now?
Sure.
Yeah,
All right, thank you very much.
Thanks a lot. Thanks a lot for doing all these efforts for us. Mashallah, you actually made all the presentations, you did your research, and then you conducted all the sessions. You spent a lot of time. I really appreciate. Thanks a lot. And inshallah, actually, we just like Allah will give you the reward. We can only say thank you, and we really appreciate your efforts.
No, it's my small help to my community. That's the way I see it. So it's my way of giving back to the community.
Thank you very
You are
much.
doing a great job.
Thanks a lot.
Is there any possibility we can get this PPTs?
PPTs are not being shared. There's a reason for that, but everything is available on YouTube for you to look at. All right.
Okay, guys, thank you. We'll close the session now. And inshallah, hopefully maybe we'll come again with a different session with the Bhai after some time. Okay.
Thank you, Bhai and GSP.
Thank you so much.
Thank you.
It was great to attend the session. Thank you very much.
Thank you.
Thank you very much.
Thank you.
Thanks.